Oh, that's awesome. We like to do things that are helpful for you guys.
This is all rolled out of RASM and the Attorney Realtor Joint Committee, and it is a fun committee because we talk about the latest and greatest, topics and issues that you guys experience, and then we try to do some informational, whether article or panel or both, and it's I think extremely it's fun for us to do, but I think it's very important. Because it's such a wild and crazy world out there, and ever-changing legal issues. As Jody and I were talking,
should we give these to Jamie as people come in? Maybe she can.
That's a great idea.
Okay.
Yeah, I'll put them up there. Put this thing back.
Okay, what's happening? What am I doing?
Huh?
It was getting feedback.
Keep talking there. It is a couple minutes after. Just for a little housekeeping, this is what we call a panel discussion or discussion. It's very informal. We're going to talk about a bunch of things, and if y'all have any questions, roll up your hand or yell at us, and we'll go out in whatever rabbit hole or tangent that y'all want to do. I think that's a lot more fun for all of us because you have the real world experiences and that you have your own personal experiences, and it makes it a whole lot more fun than just listen to two lawyers up here just yap at you. So we want to make it informal, fun, and hopefully you walk away with some stuff. The handouts that we gave you is just basically Jody came up with our nice little presentation. That's just in writing in case you want to make notes on there, and when you have your computer, you can do that. And what other housekeeping? That's about it, isn't it?
Yeah, the other one was the questions. So you can take notes on that, and I think that's it. I think for housekeeping.
Okay. Why don't you introduce and tell her what we're going to do and what the overall is? Okay.
Thank you. So I'm Jody Ruberg, and this is Garrett Barnes. We both are lawyers in town-ish. Garrett and his firm is right here in Bradenton. My firm, we have offices in Sarasota. That's the office that I work in. And we also have offices in Tampa and St. Pete. And so Garrett and I both practice similar types of law, and we kind of partnered together. As he shared earlier, we both serve on the Realtor Attorney Joint Committee, and it is a lot of fun. And we both do basically real estate law. We do closings, we do business law, and fun fact, and I'm so happy about this, we just got, I've been calling him Little Garrett. We just got Garrett's son to join our firm. And poor guy, I've not even met him yet. But I promise I'll stop calling him Little Garrett.
You are working him very well. He's in your St. Pete office and really enjoying. He just graduated and just took the oath, and he's 2 week old lawyer.
That's the best. That's the best.
Fun stuff.
So Garrett and I partnered together to put this on for you. We kind of thought what could be helpful for you guys. So we drafted an article together to kind of go through some things for you to keep in mind when you're getting ready to put your real estate under contract, whether it's a listing agreement or whether you're representing a buyer and it's for an offer. And honestly, just to kind of set the stage, I want you to know that a lot of the things that we're going to talk about today can take lawyers oftentimes hours to conduct an analysis for. So it's not necessarily stuff that you have to know right off the top of your head. You don't need to feel like an idiot for not knowing, how to handle it or whatnot. Because sometimes, like, determining who has the authority to sign for a multi-member LLC, it's not as easy as you would think. It sometimes takes looking at several different documents and maybe even putting together some documents to be able to determine who actually has the authority to sign. So the article we put together kind of is a little teaser, and it just talks about who has the authority to sign certain agreements, because if the person that's signing doesn't have the authority, your contract could be void or voidable. In other words, it basically could be undone or unenforceable. And so it's often important to look to the deed. I mean, you know this is 101, but you grab the deed, you find out who holds title in it. And sometimes if you see it's an entity, the next step might be to go to sunbiz.com to see if the entity is, an active entity, and to see who the managers are, and to get a little bit more information. So that way you can kind of start thinking about, does this person have authority, or do I need to bring in someone else to kind of help and weigh in on that? There's a lot of things, and we're going to kind of dive into this a little bit deeper in just a second, but like you're going to see on a deed that it could be owned by an individual. It could be owned by a legal entity, which could be a corporation or an LLC. And that entity could have a single member, or it could have multiple members. It could have a single manager, or it could have multiple managers. The deed could show you that the trust, a family trust, is actually like the trustee of a trust is who holds title to that property. A lot of times your seller may not even know if they have the authority, or who has the proper authority, especially if it's a multi-member LLC. It can be very convoluted. I did one recently where, I mean, it literally took us hours because we're looking back at like old documents that were drafted in, back in like the 90s, and then it's like, were there amendments, was this updated, and so I mean, sometimes it takes a long time to do an analysis to see who has the authority. So I say that so that you don't feel like it's all on you, you must know this. And then also, I think one of the bigger takeaways, two of the bigger takeaways that I think we want to convey to you today is, if you represent the buyer, if you make sure that your contract is assignable, then it can help resolve any kind of issues. And again, we're going to talk about that more. But I think having a contract, it's provision 7 for your as-is residential contract, and it gives you 3 options. And I will dive into this in a little bit. But I think choosing the option that allows your contract to be assignable is the best bet for you, because if they change their mind, or if you find out later that they're buying it in their trust or whatnot, we can make those changes. The other thing that I think we wanted to kind of point out is that you have title agents for closings, and you have lawyers who also are title agents and can do closings. And I think the difference is lawyers, we are able to draft legal documents, we're able to issue spot and identify issues and help resolve any kind of issues as they arise, to make sure that you get to that closing table, and that your deal doesn't blow up, and that you get paid, probably most importantly. Garrett shared with me just before we started something that he likes to say, which I'll let you share with them, which I think is a great line, that nobody gets, sorry, I'll just say it.
Nobody gets paid unless it closes.
Right, that's it. And I think that's great, because it's like a lot of times, and not to knock title agents or title companies, but we are able to look at the whole picture and be able to issue spot and address things before you even know there might be an issue, and we can resolve it. And you might not even know that we've resolved it in the background, but we've taken care of it, so it doesn't prevent you from closing your deal. So anyway, all of that to say, that's just kind of like a little intro. We're going to kind of switch back and forth between questions, and Garrett is going to take the first question. As he said, please, by all means, ask questions as they come to you, or we can maybe even ask questions at the end as well. So the first question that Garrett is going to tackle, and I knew this didn't work earlier.
And remember that the article is making it legal who signs the dotted line. Remember, it starts when, if you're representing a seller, the listing agreement. If you have the wrong person on a listing agreement, you may not get a commission. If you have the wrong person on the contract, you may not have a contract. If you have the wrong person on the deed, somebody's going to get sued. So get it right from the get-go. And then once you get it right from the beginning, then it carries through all the way to the closing. And, as closing agents, attorneys, we will monitor that. We don't trust the contract. We don't trust the listing agreement. So that's our job, is to find out actually who is the buyer, who is the buyer, and who is the seller, for that matter.
It happens again.
So we will fix things as we see it. If you do get it wrong, MLS is not always right. The property appraiser is not always right.
Yeah.
In fact,
A lot of, they're notoriously wrong. So we'll talk about some best practices as we go through these questions as well.
Garrett, Jamie just asked if anybody has questions, and you guys pulled us to this. She asked if we would repeat your question because we have the microphones. So if we don't, tell
Great,
us to do
thank
that.
you.
Okay, Garrett, the first question is, if only one spouse owns the homestead property, should you get both spouses to sign the listing agreement, the contract, the deed?
Yes, very good question.
Thank you.
And we see this quite a bit because, okay, you pull a listing, only one person owns the property according to that. You put that on the contract, your listing, hey, everything is great. But remember, under Florida constitutional protection, remember that word, that's big, that's the highest protections there are for homestead, that a spouse cannot sell or mortgage the homestead without the other's consent. Which means you might be able to have one party sign the listing agreement, but when it goes to the contract, if the other spouse says, no, I don't know anything about this, I'm not going to sign this, you're not having a deal. So the best practice here is okay, Jane Doe, are you married? They're going to say, well, it's none of your darn business. Well, yeah, it is, because you got to make sure you have a valid listing agreement, a valid contract, and a valid deed. If only one spouse is on title, when I do a contract, I like to get joined by John Doe. That way, that spouse can't object at the very end, or we know in the beginning whether there's going to be a problem, and then you can stop in its tracks right there to have it before you spend all your wheels and all your money, marketing and everything else, and it's all for naught. So the correct procedural for you is to, if it's homestead property, get both to sign even though one's on. Okay. Okay, joined by, it means if only one is on the deed, one owns it, we put joined by spouse. If both of them are on there, husband and wife, you always put husband and wife. John Doe, Jane Doe, husband and wife. That means you got both of them. You can do it either way. Yes, ma'am.
John Doe is on the deed.
Yep.
Is on everything. He is homesteading.
He has homesteaded it.
Jane Doe never slept in the house.
Yeah.
Never.
Okay.
Does she still get to sign it?
I like where you're going. In Florida, you're married or you're not married. I don't care if they haven't seen each other for 20 years. If he's married to her, she lives in Alaska, we got to go to Alaska to get her signature. If she's in prison, we got to go to prison and get her signature. Period. Because it's a constitutional protection of the protection of home. There is no. It is, you got to get their signature or you don't have a deal. So that's a very good question. Yeah. Yeah. If you're married, you got to have the spouse sign anything dealing with the homestead. Yeah. And that gets very frustrating because we've dealt with that in the past. Yeah. Sometimes we don't even know where they are. The client, we don't know where they are. Well, we got to find out where they are.
An issue. We still have to figure it out.
Yeah, there's no ignoring it. Yes.
Because forever, he's on the deed, he's on the mortgage, she is not. They were married in Canada, but it was never filed properly in the States. I left her off the listing paperwork.
But they're still legally married?
Apparently not, because did it in Canada, didn't do anything with the paperwork after the fact. We had a certain amount of time in which to do.
Yeah. Well, that's a research thing we would have to do to determine, because we're insuring title. What that means is that when that buyer walks away from our closing office, there are going to be no claims coming. And if I know about that situation, I'm going to say, hold up.
Yep. I
got to do the analysis or have a Canadian guy say, are they married or not? Because a Canadian married couple would be recognized in Florida as a married couple.
Because they did not.
Okay. Yeah, but see, we don't go with if I believe it or not. I got to have facts in order to write that clear title. I would ask is the husband your client? And he's a Canadian?
Oh, they did a little quickie and, quickie, okay. What I would do is have the, you know, because the husband wants to know if she's gonna have to sign off, because I take it they're not a couple anymore.
And if they're so friendly, like, it doesn't hurt to just have her. There it is. Worst
I
comes
would
to,
have joined by the spouse. When in doubt, because it's a constitutional protection, it's such a high level that you have her sign anyway. And as she said, it does not hurt. Okay, and I would put as husband and wife.
yeah, I mean, I think that you're better off having her signature than not, because what happens if you have her signature and it's not necessary? Nothing. What happens if you don't have her signature and it is necessary? She could put up a stink. Yeah, maybe to change the party, like, an,
Yeah. And if she says no, then you know you have a problem. Good, okay,
yeah,
that's great. I'm glad we talked about it now.
better safe than sorry.
Yes.
Okay, so we'll go to the next question, which also Garrett.
One
go-
more question.
Yeah, please.
When you're, one more issue, another best practice, when you're filling out your contract or your listing agreement, always get in the public records to pull up the last deed. That is a good practice in the fact that you know how the spellings, you can compare the legal description of what you're going to be on the deed, and you know who the parties are on the deed for you to think about it further. So, you know, a lot of people don't know, you know what, I may have put that in my trust last year, but I don't know. And if you have the wrong parties on your listing contract, you know, guess what? You may not have a valid binding contract. So it's best practice always to pull the last deed, get in Sarasota Clerk of Court, Manatee County Clerk of Court, takes 2 seconds to pull up the last deed.
Yep.
And it'll also show you, wow, this person has about 15 judgments. What's that all about? Then you can start asking questions and be proactive.
Yeah.
Okay, sorry.
No, don't be sorry. What happens if one spouse owns the homestead property but is separated from the other spouse and the other spouse refuses to sign or cannot be located?
You want to answer that? Or you want me? Trouble with a capital T. You are not closing, you're not getting paid.
Yep.
So again, they may not see that person for 20 years. You may not locate that person for 20 years, but if they are still alive and they are still married, they will be required to sign the deed.
Yeah.
Okay.
Better safe than sorry.
Yes. There is not a workaround for that.
Your deal stalls, your.
The deal stalls. No, I mean, you have to tell the spouse that owns the property you got to go find them. And hopefully when you find them, they're amicable. And hopefully they're not putting the hand out for, yeah, I'll sign, but I want X dollars. Or if it is that acceptable?
And the husband had to take the wife, the ex-husband, or the husband, I can't remember anymore, it was so long ago. The husband had to take the wife to court, and the judge had to force the other spouse, the wife, that didn't want to sell, to sell the property.
In Florida, it's called a partition action.
Mhm.
In Florida, you can't do a partition action against your spouse. You got to wait till they're divorced, then you can do it. So yes, good idea, no go.
These 2 questions are just for only if it's homestead, not if it's not.
If it's not homestead, then the person can sign as a married man without the joinder. Yeah, the only caveat is we'll put what we call non-homestead language in the deed saying this is not the homestead. This is only his, it's not his homestead nor the homestead of anybody else. So that's
the distinguishing factor for sure. And you can find out by looking at the property appraiser's website if they've claimed homestead. If they've not, you're in the clear. If they have, your flag, your antenna should go up. Where's the spouse?
Yep.
Second home, vacation home.
Vacation
Like
home,
not-
don't need the spouse to
Like
sign.
not a homestead.
Remember, a couple can only have, most of the time, one homestead. That's it.
For that, I thought that Florida was joint property state, so one spouse could not do something without the other spouse's permission. Totally wrong.
Well, that's what we're talking about. You can't sell that. A spouse cannot sell the house with the other's consent. Yeah. If it's in his name only, yes. Yes. If it's in joint names, of course you have to be participative.
Where'd you say?
Because they'll need your signature, you're on title with him.
It's like separating.
If it's only in his name,
It's a,
he can do anything he wants with the property without you. Absolutely. Now, you may have claims to the proceeds, but he does not need your consent or joinder to sell that non-homestead property.
the other question we just got is what is a partition? And it's basically a legal action that helps separate the asset, the real property.
It's a forced sale by a judge. You go to court for non-homestead property. Say Jody and I own a piece of property. She wants to sell. I don't. She can go to court and a judge will say, you will sell it. And here's how the proceeds are going to be split. It's a forced sale by judicial procedure. It's a very good tool that we have. Okay, well, let's, any other questions on this? And because we're going to come back to it a couple different ways. Okay, next question for Jody. She kept all the hard questions and I got all the easy ones. So I'm enjoying this. Okay, if a buyer is buying a rental property or commercial property, should they buy it in their individual names or some type of an entity?
Yeah. Yeah, so if a buyer is plans to rent it out, whether it's commercially or to people that want to do Airbnb, VRBO, rents it out for an annual, your antenna should go up liability, slip and falls, trip and falls, drownings, mold exposure. They want to, and you are not their lawyer. So it is not your responsibility, but likely they should or would want to put that in an entity, in a limited liability company, or another type of entity that would basically limit their liability exposure to what's in that entity. It keeps their personal assets separate from their business assets. So very much, I think that that's a wonderful tool, limited liability companies or other type of entities. And there might be some tax planning that comes into it as well. So like they might, their CPA might tell them what type of entity that they should use. One thing to distinguish here, and this is, of course, like we just discussed, if it's a secondary property, it's not their marital home, it's not their main home. If it is in an LLC, they're not going to get to take advantage of that homestead exemption. So that's, the benefit is it being in an LLC, the benefit is you're limiting your liability. The downside is you're not getting that homestead exemption.
The homestead cannot be owned by an LLC to get the benefits. So that's why you always see homes either owned, husband and wife or one person individually, or it could be homesteaded if it's in a trust, if it's appropriate trust. Yes, ma'am.
What if it's what?
Question, what if it's the primary home and never homesteaded it? It can still be their homestead. It's just not classified from a tax standpoint. So you're paying more taxes than you should. It can still be considered your home. Yes. Your home is where you think your home is. You have to recognize how that home, your homestead, is still owned. Yeah, even if you don't have it on the property appraiser as a homestead, but it is, they just forgot to do it, which we see all the time. They're just paying more taxes than they should, but it's still their homestead. Now, so that's why we're always, I think, she and I and all the other closing, we send out information sheets requesting for information when we get a contract in. That is always, you'll see that's probably one of the top couple questions that we ask. Yes, ma'am.
Does the law like trump their property?
What was the question?
Go ahead. Okay. We do have a new waiver of homestead available to us in the state of Florida. It's only, a couple of years old?
What was can you repeat the question?
The question was, is there any laws that trump the homestead?
They like freedom. Marital property agreement?
You talk about a prenup?
Yeah.
Does a prenup trump the?
Like constitutional.
The answer is maybe. If you have the correct waivers in there, the new constitutional waiver of homestead in your estate planning documents or prenup, it does. But it's fairly new and untested. We don't see it very often.
Great question, though.
It was a very good question. Yeah.
They didn't care, but the spouse that was the initiate of it, it's like.
Yeah. It's such a, again, it's a right created by the Constitution. So, you just can't say, I waive it, Garrett, here's an email, just don't worry about me. No.
Not that simple, yeah.
You got to have it done by lawyers in the right language and make sure it's all correct. You got to have, and it's most likely in a prenup, you have to have your own representation. Not an easy thing. Okay, next question. Oh, sorry.
Sorry,
No.
one quick question. In an LLC.
Yeah.
So in my properties, when my rental properties, when I go to refinance, right, I always set it up in an LLC first,
Yeah.
I set up my bank accounts, have everything separate for that corporate veil. But then, when I go to refinance, because rates are low.
Yeah.
They always want me to refinance.
Right.
In my own name.
Right.
Just, but then like, what about the next step after that? Am I really taking a big risk of having a due on sale clause or?
Absolutely, because if you put it back into the LLC, guess what? You're in default of that mortgage. So what it is, it's stupidity on the lender because they can put you as a guarantor and,
That's right.
and be legally and be whole in case you default anyway. It's just their internal checklist that they can't think beyond that. And it's so frustrating and that we can't talk to lenders, but they tell you to do it all the time. Even taking it out of your trust. Now, taking it out of your trust, individual name, putting it back into the trust does not trigger the due on sale clause. Assume it's a revocable trust, but the LLC, not only would it be a default, but you would have to pay doc stamps on the deed. So, but it's a default that you don't want if you have a low interest rate.
Yes, I dig my heels in on that. Because, and that is,
Yeah.
that it's counterintuitive when you have to sign a personal guarantee. If you have an LLC, a lot of times, 95% of the time, these banks are going to require you to sign a personal guarantee that says that if my LLC defaults, I, John Smith, personally, I'm going to pay you. I'm telling you, I'm going to pay you. And so that's what this gentleman is kind of proposing here. And I think that it is important to keep it in your LLC for if it's rental property for the liability protection. And so I, try to dig your heels in as much. I'm sorry?
Now that I've done that, I have this one property that's in my name, but I really don't want it in my name.
Yeah, I think you're gonna have to work with the lender on basically getting.
You'd have to get lender's written consent
Mhm.
for that to happen. And that's what the due on sale provision says. Without the lender's consent, you can't do this. And you may want to do that. Typically what they're going to say is, yeah, you can do it, but refinance with us. Get a whole nother set of fees in there, whatever.
Yeah.
And from a liability protection, the other way to combat liability is bump up on insurance.
That's the other thing, with insurance also. Now I need to have insurance in my personal name, and it used to be in
Yep.
LLC. and
Yeah.
do all that together.
Yep.
That there's some rules.
Right. But don't be in default. That's the key. All right, well, let's do the next one here.
Okay.
Buyer has just completed estate planning, touched on a little bit, with a trust. Should the property be purchased in their trust? And does this create any liability protection? Jody?
So a trust is more of a estate planning tool. A trust is used so that way the individual can avoid probate. Once the person passes away, probate is a very lengthy, arduous process that you don't want to have to deal with. So that's generally speaking why people will initiate a trust. Something that people often do is they spend thousands of dollars having trusts drafted by an attorney, and they completely forget to fund the trust. So when they're buying rental properties or maybe not rental properties, but when they're buying their home and they know that they want it to go to their heirs through their trust, they forget to buy it in their trust. They forget to fund the trust. So it is important to purchase it through the trust. Obviously, deeds can be drafted to kind of fix that down the road later if necessary. But it is an estate planning tool, and I think that it's less about liability and more about avoiding probate.
Yep, because it doesn't protect liability. Two things, if I can add to that.
Please.
The flow of the money. The seller is to get the proceeds. A lot of the times, well, yeah, I created my trust. I put the property into it, but they never set up an account for us to pay the seller. Well, just give it to me individually. They shouldn't do that. They need a account owned by the trust. There was a lawsuit a couple of years ago where a lawyer did just that. It was a $6-7 million deal. The lawyer, it was owned by this trust. The seller didn't open a trust. The guy said, you know what, just put it in my individual name.
Yeah.
Lo and behold, he dies like a week later. And being that it's if it's individual name, it has to be probated. And that goes to its will rather than the terms of the trust. Well, guess what? The will had to go into a whole set of different people than the trust. So the proper procedure would, John Doe, go set up an account owned by that trust so it flows into the right entity where you want it to be. So not only is it contractually bound, because the contract says we have to give it to the seller, it practically it has to be. Uh-huh.
I just did this, so I just put my own house in there and go trust or whatever, but then, I wanted to eventually make that a rental property. And then I was kind of been confused whether then should it stay in the trust or does that need an LLC underneath? Can you put an LLC in the trust?
What you would do is the property would be owned by the LLC and the LLC would be owned by your trust.
Trust is up here.
Yeah.
Trust, your trust owns a bunch of stuff, and something that your trust owns is that LLC, which then owns the house down here.
The trust, the LLC should own it. Your trust should own the LLC. To fund it is what to transfer your assets into the trust to make maximum benefit of the estate planning that you just did.
Garrett, I had raised this with Jody at before the class, but I currently have a listing. The property is actually called the person's name indenture of trust. That's what the deed reads.
What's it?
It is called the Harriet Sherman indenture of trust.
Okay.
That is what the current.
That's what's on the deed as the owner of the property.
Now, she is in a nursing home. She is still alive. It is the daughter who, by 2 amendments to the deed, was named as a co-trustee. So when I took the property to list the property, I ran the trust and the amendments by one of the legal firms in town. And they said that, yes, this daughter has the authority to sell the property for the mother.
As a successor trustee. Yep.
Everything was fine. We put the contract in that name. We are now under contract. The problem is that the seller, the daughter or the seller, is in the process of setting up this account that you just talked about for the proceeds of the sale. She has been to 2 banks. Now, she lives in Minnesota. The daughter lives in Minnesota. The home is here. The mother is in.
She's incapacitated.
No, well, yes and no. She is alive. She's in a nursing home, but she can still sign documents, but it's the daughter as the co-trustee who really is the one who is selling the home for her. She has tried with 2 different banks in Minnesota to set up an account for the proceeds, and I did not pick and pay for title. The buyer picked and paid for title. I would have gone with the offer if I was picking just for this particular purpose, because it was a bit of a complicated trust. So anyway, they picked someone, I sent all the documents to the title company. They agreed that yes, this was fine. The lady had the authority, the daughter had the authority to sell. But now the daughter is having a hard time. She has been to Chase and a local bank in Minnesota, and they said that it cannot be set up. This indenture of trust is a financial and corporate document that initially there was a mortgage attached to the property. It is no longer there. It was paid off several years ago.
Well, a trust is not a financial product.
Okay. Well, this indenture of trust, they're saying that they cannot set up a bank account to accept the proceeds in the name of the Harriet Sherman indenture of trust.
Why?
She's been to 2 different banks. They said that if her mother was dead, sounds terrible, but if her mother was dead, they would be able to set up an account in that name. But because she is alive, so now my seller, I said, I'm sorry, this is so much above my pay grade, and I'm not a lawyer. I can't give you.
And maybe, that's a lot of facts in there. That's something I just can't answer because we don't have the trust and that analysis. But keep trying different banks. Maybe keep trying local banks. I don't know.
I said to her as well.
So what's the solution to get the money? Are they willing to just give it to the mom?
No, we haven't got that far yet.
So, is that going to hold up your closing? Say the closing is saying, I can't give the money anywhere. We can't close.
We don't closing until mid-November. So
Yeah.
The contract is assignable. So again, if we had to make a change, but The problem, as I said, is that the title company basically said that everything was okay. They sent it to their underwriter. All of the documents said everything was okay. And everything was going along
Yep.
until she tried to set up this bank account. And I said. to
And
her,
because that's a
I said,
bank issue, that's a bank issue, which is out of our preview, but
Still has to.
but it's still a major part of the closing because the seller wants their money now.
And I said to her, the lawyer who drew up the initial trust is here in Sarasota.
Perfect.
I would
think-
get that person,
yeah.
I would get that person on it.
Yeah,
I said to her, spent a lot of money.
Yeah.
Yeah.
Did drawing up these
Yeah.
documents. Go to that
Yeah.
lawyer. and
Absolutely.
even if you have to pay to.
he
draw
can
up
help
the
resolve this for
document.
sure.
Go to that
Or
person.
she, I shouldn't be so sexist.
She's not real big on this law firm that drew up all the documents, so she went and thought this would be simple, just setting up the bank account. But obviously it's more, so I guess my.
But from
question
her
is-
standpoint, it's important that an account is owned by the trust, because if she's elderly and she's infirmed, possibility of
Same
death
thing.
coming around the corner, you need to avoid probate.
I guess aside from this particular personal thing, what is the difference between a revocable living trust and an indenture of trust? That is the first one I've come across where the deed says the person's name indenture of trust. What is it?
I'm not.
I'm not familiar with the
Yeah,
indenture trust,
revocable
but it
and
all depends on,
irrevocable.
but all depends what's in the body.
Irrevocable.
Most trusts we deal with are revocable,
Exactly.
which means that it's controlled by the grantor of that. You see very few irrevocables. You deal that with advanced estate planning, like with life insurance trust and that type of thing.
This indenture of trust.
But if it says in its body, this is a revocable trust, you can call it trust anything you want to, as long as it's defined correctly in the body. And what that means is that the buyer or the grantor has the right to amend, revoke, modify, So you can call it I see trust, Garrett Barnes Trust. I don't have to have the word revocable.
We are running short on time. I want to keep
Yeah.
us on our timetable. So
Okay,
I'm so
that's fine.
sorry. We can kind of, so this next question is, what is the way to handle the signature block on a trust, on contracts and a listing agreement?
Okay, very quick. The legal way, like what you were just talking about, the legal way to put it on your listing agreement, contracts and deeds is John Doe as trustee of the John Doe Trust dated such and such. A property is owned by the trustee in capacity in that fiduciary role, not the trust. That's very important. So it's John Doe or Jane Doe as trustee of the Jane Doe Trust dated such and such.
Okay,
Okay.
this next question
Yeah.
is also, let's see, if multiple people are the buyers, should they own the property as joint tenants or tenants in common? And should you structure that in the contract?
Very good question. If, say Jody and I, unrelated, are owning the property, we buy a piece of property together
As investors?
as investors, we can either own it as tenants in common, which means that if I die, my half interest will go to my estate.
Mhm.
As opposed to joint tenants with rights of survivorship, if we owned it, Garrett Barnes and Jody as joint tenants, rights of survivorship, if I die, she gets all my interest in avoiding probate. Tenants in common, I would have to probate my interest to get to my kids or wife.
So it's important to know when they're buying it, what their intention is going forward. Again, I think another good reason to have.
Again,
them
it's
working with-
remember your hat. You don't want to be giving estate planning advice. Otherwise, you could possibly be sued if things didn't turn out like they wanted.
Yeah,
So in that respect, because, maybe Jody and I, advice put in joint tenancy, maybe that's bad advice. Maybe it should have been at an LLC.
yeah.
Okay.
Tenants in common, the kids are the people who fill out a family, the joint tenants.
I'm sorry, what was that question?
Joint tenants, your partner will get 100% if you pass, but tenants in common, if you pass, your kids or somebody else can still come and get your bill.
Yes, that upon death, it automatically goes to the joint tenant, the survivor of the two or three. Whereas tenants in common, my interest, my half, say we owned it 50-50, my half would go toward my estate and she would become partners with my kids. Okay, yes, sir.
Question, not gonna close for about 8 months. Buyers are married, but it's right now, that contract was just sent over, from the builder, it's just in the wife's name. And she's debating whether she's gonna put the husband on there or not.
Is it gonna be their home?
Yes.
I would why not? Was it just easier to was she here in town and it was just easier to have it under her name?
I think, but do we have time, a question, do we have time, since the contract was just drawn up today, before we have 8 months to close?
Yeah.
Take it
Yeah, plenty of
off.
time to do an assignment of contract, assuming the contract allows for that. If the contract only allows for assignment with the seller's consent or the seller's consent, you'd have to get their consent, then you can do an assignment of contract. You have plenty of time to do that. And if they're getting financing, the lender's probably going to want both of them anyway. If there's a mortgage, the husband's got to sign the mortgage anyway. Absolutely. If it's going to be their home, remember, you can't sell or mortgage the home without the spouse's consent. Yes. They need to talk to a lawyer, estate planning or marital.
Yeah.
Okay, but
All
very,
the-
very good question.
Reason, it's helpful to use lawyers when you do your closings. Okay, so Garrett, who signs the contract should the owner have passed away?
Another great question.
Thank you.
We're living in an area that handles that. So if a owner passes away, let's go back to your example, if it's joint tenants, no problem. We just get the survivor to sign. If it's in tenants in common or I own the property individually, well, guess what? My interest has to be probated. So you got to go have a probate started with a personal representative. So we get the person's will, find out how that's going to happen, who the personal representative, and that's going to slow things up. It's not going to prevent the closing, but it will slow things up in order to have the proper party sign. Because until a probate is started, there's nobody with authority to sign your listing agreement, the contract, or the deed. If it's in trust, who was I talking to? If it's in trust and the person dies, typically there's a successor trustee appointed. Part of estate planning, you create a trust is to avoid probate. So we would look to the body of the trust, find out who the successor is, boom, we have it there. Okay.
Garrett, why don't you ask me a question?
I'm going to do that right now. Related to this, if power of attorney is to be used, how do you structure the contract and should you review the power of attorney?
Yes, you should absolutely review the power of attorney. I think that a lot of times people just assume some misconceptions about powers of attorney are one, first and foremost, that it's still valid upon someone's death. It's not. A power of attorney is a document that's drafted. Say I am the principal, I'm the person who's giving authority over to somebody else. Say I'm giving my authority to Garrett. Garrett's going to act as my agent or my attorney in fact. And I'm saying in this document that could be 4 or 5 pages long, what he has the authority to do. Sometimes you can list out and say, I want him to be able to open bank accounts. I want him to be able to transfer money. I want him to be able to buy and sell my real estate. I want him to be able to manage certain, anything. There we go. And so, but people can pick and choose in that power of attorney what authority they're giving to somebody else. So I could say, I want him to do all of these things, but I don't want him to have the authority or the capacity to buy and sell real estate for me. And so if that's the case, that's a very important distinction. So somebody could say, oh, so-and-so has power of attorney. Don't just trust that that means that that person has the ability, the authority to sign your contract to be able to do a real estate transaction. So it's very, very important that you look at that power of attorney or have someone, a lawyer, look at a power of attorney for you and tell you what authority has been granted in that power of attorney. It also needs to be recorded. If you're doing a transaction where an attorney in fact is signing as the party, Garrett as attorney in fact for Jody Ruberg is signing, then that power of attorney needs to also be recorded with the deed. So it's just a distinction. So yes, it is absolutely, you should review it or have someone review it. Again, these things can get complicated. So don't feel like you shouldn't take that responsibility on yourself. You definitely want to enlist the help of others, of legal counsel to be able to help you with that.
State was actually actually a medical power of attorney and then.
Right, a healthcare surrogate is very different than a power of attorney. Yeah, yeah, and people don't understand, unfortunately, people don't understand the difference. So, and that's something that when I was talking, and I'm gonna talk about this in 2 seconds about the LLC, people don't know who has the authority. They just think that these documents are drafted and they think these documents do a certain thing. And then when we start to look at them, we're like, these documents don't actually do what you think they do. So again, an important distinction, yes.
And the ones hang on, we'll get 1, 2, 3. Don't print off one from Google, sign it thing, that is a do-all. Because it may or may not be good. And when you're in this situation, owning property worth a lot of money, you don't want to assume.
So.
Linda?
Once that's recorded, that's public record then, right?
Yes.
Yes, ma'am.
Okay, so you can't
But that's good, but remember, power of attorneys can be revoked or terminated. So we want to make sure with the principle that that person has not done it, and Joe and I were talking, we'll always have an affidavit signed saying that the power of attorney has not been revoked or modified that prevents them from doing what they're doing.
Valid when the person is alive, correct?
That's correct. That is absolutely correct. I've gotten so many calls. My uncle is about to pass away. Can you hurry up and draft a power of attorney? That power of attorney is going to be void once that uncle passes away. It's only good for while that person is alive. I know it seems a little bit counterintuitive, but it's great for like if you want to go off on a trip to Europe and I don't want to have to deal with the real estate closing, I'm going to designate Garrett to be my attorney, in fact, to handle it all.
That might have answered my question. In Florida, is a power of attorney or do you have power of attorneys? Is it one form and you check the boxes of what you do or cannot do, or do you have specific power of attorneys for specific things?
It can be both. A durable power of attorney is
And separate.
Yeah. You can have in the durable power of attorney, which is very broad, you can have specific powers included or not included.
Mhm.
We do what we call limited power of attorneys. If we own a piece of property together, I'm gone, I would sign one, say, hey, look, for this transaction, for this property only, you have the power to do this. So it could be all the above. And that's why we have to look at the language on each power of attorney to make sure they have the right language in there. Because it's got to have specific words in there to give the power to the agent, convey, contract, sell, that type of thing. If it doesn't have the power of sale for real estate in that power of attorney, we can't use it. Jody?
I have a question. Can a trustee delegate their duties under a power of attorney?
Okay, very good. Typically not, unless it's specifically set forth in the trust, because a trustee is under a fiduciary obligation to perform his duties under that trust. And they can't delegate or give away those powers to somebody that's not named in the trust.
What if the trustee wants to like not do their job and they don't want to be burdened? What happens next?
Then the beneficiaries better fire that trustee.
And so then what document has to get drafted?
I don't know what.
Like a successor trustee document?
Oh, yeah. Yeah.
Another document that the lawyers can like put together and like.
Yeah, if the trustee's not doing their job, the beneficiaries need to go to a lawyer to kick out that trustee appropriately.
So that's a way that a trustee, I guess, could delegate their duties, is basically like, I want to step down, I don't want to actually handle this. So then we're going to appoint a successor trustee and the first trustees.
But we have very limited flexibility in these trusts because it is a fiduciary role, not just the person I can do whatever I want, because they have to comply. And everything they do, they're being when they're in that role to fulfill the terms of the trust. Yes. Well, it can be a number of ways. If there's provisions in the trust that the beneficiaries can vote, they can be voted out by a successor. The grantor can always remove the trustee and put another one if he or she is not it, or you can go to court.
Yeah. So the typical lawyer answer of it depends.
Yeah.
Okay.
Okay, I'm going to ask you a question.
Okay.
Okay. Let's see. If an LLC or S Corp, an entity, is the seller, how do you set up the signature block and make it legal and ensure they are signing? Am I the right one? Yeah, signing in the correct capacity.
Okay. I think
And-
that question goes with the other questions. I'm going to answer both questions at the same time.
Okay. The
Yeah, those two are very related. And let me just read the second question. So
Sure.
you're going to do them both. If an LLC or S corp is being used as a seller or buyer, should you confirm that the person signing has the authority to buy or sell?
Okay, so this is what I alluded to in my intro. So you go and you look at your deed and you see, and you're the listing agent and you see on the deed, oh, it's an LLC. Okay, so you need more information. It's ABC LLC is the entity that owns the property. So the first thing you do once you get that deed and you see who owns it or which entity owns it, you then go, presumably it's a Florida LLC, you pull up Florida Sunbiz, sunbiz.com, and you look and you make sure, is it an active entity? A lot of times people will have an LLC and they'll forget to pay their annual dues at the end of every year. And so then they're like on a little temporary, suspension until they make up those dues. So you want to make sure it's an active entity. And you also want to dig in and get a little bit more information. Is it a single member entity? Is it basically the guy you're talking to or the girl you're talking to? Does she own the entity completely, or does she have business partners? Are there three, members? So it's important at this point to gather the documents that are related to it, and these are the governing documents. So the operating agreement, it might even be, if it's a corporation, it might be the bylaws. This is the example I was giving earlier where I had to do one recently where it was a huge multi-million-dollar transaction, the sale of medical practices, and it included a lot of real estate. And their bylaws and their shareholder agreements and everything were like freaking ancient. And they hadn't been, amended or updated. And so it was like it was literally pulling teeth. Like, what are the governing documents? And I mean, it was a process that took absolutely hours. So this is why I tell you, don't feel like you need to take all of this on your own, because if it takes a lawyer who's been practicing for 12, 13 years, hours and hours to figure it out, it's not going to be that apparent. Sometimes it's going to be super apparent. Sometimes they're going to be like, yes, I'm the only owner. I own it. It's manager managed. I'm the manager. And you can see that by looking at the governing documents. Then when it comes time to signing your documents, that person can sign it as John Doe, manager of the LLC. But it does take a little bit of an analysis to get there. And so, that's another thing why, what the realtors that I work with, I always tell them, I'm like, keep my number on speed dial. And I'm sure you do the same exact thing. And it's like, feel free, I will walk you through this analysis and we will get through it in 5 minutes. Or if we can't, if it's one of those situations where it's going to be hours and hours, like the example I gave earlier, then we can tell you that as well. But at least it gives you peace of mind that you've checked the right boxes.
And it goes back to, how do you fill out that contract to make it legally binding? That's exactly what she's talking about. Because if you have the wrong person, guess what? You may not have a valid contract because it didn't have the authority to sign that contract or listing agreement, much less deed. 1, 2, 3.
I started. It's like the bottom where it says, it's been delivered and by whom and when. If that's not filled out, is it unenforceable if that's not checked and sent back to the seller, like on the listing?
Well, the contract is not valid until signed and delivered, correct?
So I never see that done. So you're saying it doesn't?
You as a realtor better confirm that it was delivered appropriately by electronic means or whatever. Because otherwise they can rescind that.
Do we still need to go back on that bottom section and say it's been delivered via email at such and such date?
I would definitely document that, and whether you send it back or you can scan it, you can do whatever, whatever method you want to make sure you represent the buyer or the seller, an offer has been made. You sign it. Oh, on the listing. Okay.
I just worry that they could always say wasn't signed.
The best practice is document your file to the nth degree. So yes, get it where they have received it.
Get all the signatures, put it in a nice little pretty bow, email it. Here it is, fully executed.
The other thing that I'm on the offer, when you hate how in Florida doesn't use like a counter offer form a lot, so they use, you know, just like crossing out the initialing. But then this box where it says that needs to be counted. Does that need to be checked? Because that drives me bonkers, like, so, you know what I'm saying?
Yep.
Okay.
Not necessarily. If they're initialing all the counters and it's done appropriately and sent back and they've received that, then it's a valid contract. Best practices would be to mark the box. Yes, and if a contract, you know, back in the good old days, it used to be done by handwriting, and sometimes the contract got so messy, you couldn't figure out whether you had a valid contract or not. Again, at some point, start over. Just, you know, you don't have a contract anyway, just start over. Make it clean, that way you can see if it's enforceable, that type of thing. There was another 1, 2, 3 over here. Yes, sir.
New to Florida law, so I'm trying to get myself up to speed here. So I just want to make sure I'm understanding an LLC standpoint with Florida law. So my seller is an LLC.
Okay.
And so my line with my name of my seller is going to be that LLC, but it's my hand, John Doe, manager LLC, that's going to be my signature line, but my seller is just going to be ABC LLC. Is that correct?
Your seller party is going to be the LLC, but the person who has authority to sign on behalf of the seller, the party, the LLC, is likely going, if it's a manager-managed entity, is likely going to be manager. But again, it definitely, you know, it depends, answer. It just depends on what the governing documents do say. Yes, yeah. Well, and that goes back to what their operating agreement says. So the operating agreement might say there's 3 managers. Any one of these managers has authority to bind the company with respect to real property, or it could say, you know, it's a major decision, and so all 3 managers have to be on board, and you know, all 3 managers have to sign. So especially if there's a lot of managers involved, that's something that I would engage, you know, a lawyer to kind of just give you their 2 cents on that. Generally, yeah. So there's a document, it's called a written consent. It's a resolution, like a corporate resolution, where we can draft a written consent that basically says, this entity has authority to enter into this real estate transaction, and it has the people that need to sign will be signing that corporate resolution.
Magic.
So, you know, since we as realtors, you know, have to walk that line on interpreting the contract, are we interpreting and acting as an attorney when we're not? Are we acting as an attorney when we're, you know, reading the operating agreement and determining what that says?
It's a fine line, and there's a difference between practicing and that. You know, the client will give it to you. It should say, okay, one of the 3 can sign. I think you can pretty much take that to the bank and have the contract signed. When it gets confusing, then you better go to a lawyer and you not make the legal decision.
Yeah,
Is
if
it
you
fun?
feel like it's crystal clear, cool. But if you're like, I don't know.
Okay, one more question. We can do it in 2 minutes.
Okay. There it is, I think. Is that it?
Yes. No, one more. Okay.
No,
I'll do it.
this is it,
Oh,
yeah.
it was, yeah, there it
This
is.
is it, yeah.
Okay.
Do you want to ask me?
Oh, I'll ask you. If buyer wants to use an LLC or S corp, but has not set it up yet, can you use that entity as a buyer?
No. So, absolutely, an LLC or any entity, in order for somebody to be signing on behalf of it, it must be an active entity. They must have authority to do it. This is where I was saying in the beginning, paragraph 7 of your as-is residential contract asks you 3 different questions regarding assignability. The first question is, may assign, and the buyer may assign and thereby be released from any further liability under this contract. The second question is, the buyer may assign but not be released under this contract. And the third one is, the buyer may not assign this contract. As a buyer representative, I always tell my realtors, check that middle box, may assign but not be released under this contract, because it allows them the flexibility to change between, say you're under contract today, but you're not closing until a month from now, it gives them a month to do that analysis. Oh, should I put it in my trust? Should I put it in an LLC? Should I, let me consult with a lawyer. But what's important to you is I want to get this contract signed today. So I would get the contract signed, but I would make it assignable, that middle box. First box is also assignable, but it's unlikely that your seller agent is going to agree to it because it allows them basically to get out of the contract. So that middle box is going to be your happy medium one, and it's going to allow you to later assign it between the date that they're signing the document and the date they're actually closing. So no, do not have somebody sign on behalf of an LLC in your contract if it's not an active entity, if it hasn't been set up yet, if you don't see it on Sunbiz, red flag, have them just enter into the contract, whether it's individually or whatnot, but make it assignable.
No, we'll get to you in just a minute, but one to add to that, I
Please.
use the assignability a lot. Say it happens all the time where the wife's down here, finds a piece of property they want to buy, but he's not here. I like to get, and I'm sure you do too, get the contract signed up as quick as possible, get it bound up. So I put just her as a buyer, assignability, and then at a later time, I do an assignment of contract, not an addendum to contract, because it's signable. If you can assign it, it's an assignment of contract. And then I add the husband later. That way you get it, boom, you get it under contract now, everybody's happy, we do assignment, go on with closing.
Get a call from lender saying, we don't like that box because they can assign it to John Doe and they want it changed. So how do we deal with that and still be it?
You make sure you have your buyer, your right buyers, and then you do an addendum to remove it. Sometimes you got to do what the lender wants to get money. So in other words, if the wife was only on there, but they want to add the husband, go ahead and add the husband and then do an addendum to the contract to remove the assignability.
Sure. Top of page 2 here, did we answer that one? Who signs the contract to the owner who passed away? Was that part?
Yes, personal representative
That's
or
what we-
successor trustee.
Personal.
Yeah. Or if it's a joint tenant, then the survivor.
So we are past 12 o'clock. Our contact information is up here. We also have business cards here. I'm happy to, I think if you guys want to ask more questions,
Yeah,
I
we'll
think that
stay
we're
here.
fine to entertain that. And if you guys need to leave, we understand that and you're not being rude to walk out. But thank you so much for everybody who did come and for your attention. I hope that it was helpful.
Thank you. And she's been great. I've really enjoyed looking to do another one with you. And these are always fun. So thank you very much. But we will stay here in case you have
Yeah,
any questions.
please, and feel free to ask them in the same format if you'd like.
So we're not going anywhere.
Yes.
Thank you.
No, you wanna do that?
It's just entity formation.